Raj Avasthi, in its report to centres, said that Section 124A of the Indian Penal Code, dealing with the law of sedition, should be retained with some amendments regarding circumstances under which it should be used. The Commission said in the report that sedition, being a quote-unquote colonial legacy, is not a valid ground for its repeal. But in view of the misuse of Section 124A, the panel has recommended that the centre issues model guidelines to curb any misuse. The report also listed several reasons for why the law of sedition needs to remain and claimed that the law was required to safeguard the unity and integrity of India. My colleague Ananya is the one who's getting us those details. So Ananya, what the Law Commission is proposing, explain to us how it contextually differs from what the Supreme Court has observed in this matter.
Well, Renema, this is a very, very important report that is coming from the Law Commission. And if you remember that this particular law, Section 124A, has been a talk of the town when if you remember, the Prime Minister's office had actually filed an affidavit before the Supreme Court clearly saying that under Azadi Ka Amrit Mahotsav, there are various laws that are being revisited by, the Law Commission and the Ministry of Law and Justice so that colonial laws can be repealed. But on the contrary of it, the Law Commission's report has now stated that, since it's a colonial law, you cannot say that it's not necessary. Second big reason is that it's being given out by, the Law Commission is that the existence of counter-terrorism legislation does not mean that sedition cannot exist. In fact, it is also being stated that, there was an argument that was given that there are various countries which has actually abolished the sedition law in their laws. But then here it is what is being said by the Law Commission headed by the former judge is that every country has different circumstances, and in a country like India, which is a far bigger democracy with so much of diversity, this law needs to be there.
Right. Ananya, do hold on. Let me bring in Majid Memon, a legal luminary himself. Mr. Memon, first reaction, the Law Commission is saying that 124A is required. Yes, some amendments may be needed to stop its misuse, but you can't repeal the law completely.
See, in recent times, we have experienced that 124A of the Penal Code relating to the offence of sedition has been abused grossly. See, on anyone who criticizes the functioning of the government or the functioning of a political party is slapped with the accusations of 124A, which is absolutely unfair. And therefore, I think Law Commission is absolutely right that there is a grave need for the purposes of having a relook at the provision itself, statutory provision 124A, as also its use or abuse. And I think that amendment would bring an end to this kind of abuse of process of law.
But Mr. Memon, what the Law Commission is saying, as per sources, is not to repeal the law. It is saying the law must stand, but it could be amended to stop misuse. You agree with that position, that the law should not be repealed?
No, I think the Law Commission has its own limitation. Law Commission may make certain recommendations. It is ultimately the Parliament. In the Parliament, the matter of once the Law Commission comes out with its recommendations, then the executive, the ministry, the cabinet will have to examine as to whether genuinely there is a need even to take corrective measures with regard to the statutory provision. And therefore, Parliament should be the proper place where the whole issue is required to be reconsidered and re-examined.
Mr. Memon, you don't two hats. You're also a member of the Trinamool Congress. So help us understand, if this matter goes to Parliament, this part where the Law Commission says that the law of sedition needs to remain because it is required to safeguard the unity and integrity of India. Politically speaking, what is your stand on this part, that this law is needed to safeguard unity and integrity of India?
Well, our party also believes that as far as the sanctity of the nation, as far as the integrity of the nation, as far as its reputation, the law is okay, but it should not be abused. And the manner in which this NDA government during the past 9 years has slapped 124A against the critics of the political functioning of BJP. Journalists, lawyers, activists have fallen victim to this gross slapping abuse of 124A, which certainly, according to our party's policy, needs to be curbed. And we should not permit people in power, if they are offended by a criticism of their style of functioning, a person who criticizes should be subject to the charge of 124A.
Okay.
That is absolutely wrong.
Okay. Mr. Memon, thank you so much for joining us. That was Majid Memon, lawyer as well as member of the Trinamool Congress. Ananya Bhatnagar is still there with us. Ananya, just to contextualize, why is this Law Commission recommendation important? As far as we know, currently the government has put on hold the implementation of this law. There are no FIRs that are being registered under this section in the country, right?
Well, if you remember, the Supreme Court itself had stayed this law in May 2022 while it was hearing various various petitions challenging this particular section of the Indian Penal Code, that is 124A, which deals with sedition. Now, what is the need that the Law Commission has suggested is that, number one, is that the law is required to safeguard the unity and integrity of India. It also went on to say that, social media has a considerable role in propagating radicalization against India and bringing the government into hatred, and this often occurs at the initiation and facilitation of foreign travel. That's the reason why such a law is required, so as to protect the entity of the nation, because we are such a diverse nation that we need such kind of laws to actually keep a reasonable restriction, freedom of speech and expression as well. So this is a very, very reasonable restriction that needs to be exist. However, this law had certain kind of discrepancies that needs to be changed. There needs to be particular safeguards that need to be installed by way of legislations or by way of case laws by the Supreme Court. But the Law Commission recommends that the police there can be a procedural change. The procedural safeguards can be brought. There can be more clarity in the interpretation, understanding, and usage of this law. Is what this Law Commission report says. But it is very, very significant how the Supreme Court would actually react to it after the vacations. After the court resumes after vacations, the matter might come up before the top of the country. Remember that the law has into abeyance, and in consequence of that, various people are, the trials are struck. Just like Sharjeel Imam, remember, he was charged under this stringent law, but since the law is in abeyance, the trial cannot go on in that particular case as well. So a lot of cases are halted because of that. But what would be the course of the Supreme Court? What would be the course of the government is something that we'll have to wait and watch. How would the government, the Ministry of Law and Justice, would actually react to this whole report by the Law Commission is something that is a matter of time. We'll get to know in a short while.
But what is the next course of action? Like Majid Memon was also explaining, this is a recommendation. Whether it is finally upheld or not is a matter which will be before Parliament. Any sense that you get from the government that before the term of this Parliament ends, they would want this matter settled in the Lok Sabha and Rajya Sabha?
Well, definitely, the government would do its part by bringing by discussing it into the Parliament. But there also lies another story to it, because remember that there are various petitions that are already pending before the Supreme Court of India with regards to, striking down this particular law. And how would the Supreme Court be reacting to this is also very, very important. That could also give a different shape and a role to this particular, law in the country. But we'll have to wait and watch as to how things actually pan out and what would the government be doing, whether or not the government would be bringing out this discussion before the Parliament or not, whether a MP would be asking a question about it is something that we'll get to know when the Parliament session actually begins.
Okay, Ananya, they're telling us about, how the Law Commission's recommendation is going to be, treated from here on. Just to reiterate what the important update coming in is, the Law Commission has given its recommendation about the Sedition Law, Section 124A of the Indian Penal Code, that deals with sedition. What the Law Commission has said that the law should be retained, but yes, some amendments can be brought in to prevent its misuse. The reason this matter reached the Law Commission is because the Supreme Court had stayed 124A on grounds that, it was being misused, and the government had promised that it would look at it afresh. One ground to stay the sedition law was that it was a colonial legacy. But